Today, we are very fortunate to have on the show my good friend, Clark Neily. And he is, I'm reading his bio because it's so long, but Vice President of Legal Studies at the Cato Institute. His interests include constitutional law, overcriminalization, coercive plea bargaining, police accountability, and gun rights. He's been at Cato since 2017. Before that, he had a history of Institute for Justice, private practice, and lots of other good things. He's also a professor, associate professor, or has been several different times in his career. So we're very fortunate to have Clark Neily on entrepreneurs, business, and finance. Hello, Clark.
Hi, Henry. Good to be with you.
So why don't you, for people that aren't as familiar as others, give us an idea about what the Cato Institute is, a think tank, and how that works in the world of Washington, inside the Beltway.
Yeah, so the Cato Institute, where I work now, is a libertarian think tank based in Washington, D.C. We were founded in 1977, and our goal is to come up with policy proposals that promote the interests of limited government, freedom, personal autonomy, peaceful interaction with other people, and peace both at home and abroad. And the general idea is that individual people make better decisions about their lives than collective groups of people, including governments. And we live in a country that has a constitution that was very carefully and deliberately designed to maximize the sphere of individual decision making in one's lives and minimize the size of the government footprint. And we at Cato think that our country has strayed considerably from that basic vision of a country where the sphere of individual autonomy is much larger than the sphere of government power. And so we, try to come up with various analyses and proposals to bring the country closer back to that vision of one that in which individual liberty is preeminent and government power and regulation takes a kind of a backseat to that. So that's the basic mission of the Cato Institute in a nutshell.
And I remember we went to lunch, and I got to have lunch with you and Peter Gottler, the president of Cato. And in layman's terms, he said, I just don't think people handle power really well. Uh, and so, in my layman's terms, what I think of is obviously we need a government to enforce some speed limits. We don't want people driving 140 miles an hour up and down a traffic road. On the other hand, where does that stop? Because giving that power to the government, I mean, you have so many stories and experiences that you've written about, talked about, in all your various articles and social media, and coming from IJ, where the government just does horrible things to people. And even though we have a pretty good government, maybe the best in the world. So that's the way I think about it. You say it in a much more eloquent way than I do. Uh, what led you to, I know you came from Institute for Justice, which actually, why don't you explain what Institute for Justice does and then how you moved from there to Cato and how you became a very senior scholar at Cato?
Yeah, well, the Institute for Justice is another wonderful libertarian organization. It's organized differently. Cato is a think tank, so Cato generates ideas and proposals for how to have a better public policy and a more freedom-favoring public policy. IJ's mission is somewhat narrower. The Institute for Justice is a public interest law firm that actually challenges various government policies in court on the grounds that they violate the Constitution or some other source of law, but with a similar libertarian outlook in the sense that there's a belief that in individual liberty and that the government has to be confined to its constitutionally authorized powers, and that when it tries to exercise powers that it doesn't possess or in a way that violates people's rights, then IJ will challenge that in court. And so I spent 17 years there as a constitutional litigator. I got to work on a number of really interesting issues. I came to focus in particular on occupational freedom. In other words, challenging laws that make it unreasonably difficult for people to work in the occupation of their choice. But I also worked on things like property rights and free expression. The way I ended up coming over to the Cato Institute is that I concluded along the way, sort of in my later years at IJ, particularly after I'd worked on a number of cases involving civil forfeiture, which is a power that the government has to take your property, whether it be your car, your house, or your savings account, by asserting that that property is involved in crime in some way, but not actually proving it. It's just enough to assert it. And this was really my first professional exposure to the criminal justice system. So even though forfeiture, the cases we were litigating was civil, it's still, in essence, a law enforcement power. And I was just shocked. I was absolutely flabbergasted at what I saw in terms of the utterly cavalier and sloppy way that police and prosecutors would go about exercising this power of civil forfeiture. And I began to ask myself, if they're this sloppy and cavalier when it comes to taking people's stuff, are they a lot more careful when it comes to prosecuting people for crimes and locking them up? And the more I studied the criminal justice system and the way it actually operates in real life, the more I came to the conclusion that the answer is no, they are not a lot more careful, and that, in fact, the number one purveyor of injustice in America is actually the criminal justice system. I came to believe that after studying the system for a number of years, and so the opportunity arose to come over to the Cato Institute and take over the project on criminal justice in order to dedicate myself full time to criminal justice reform, which I did for the first 4 years I was here. And then I was promoted into a position where I now oversee all of our legal studies that would include not just criminal justice reform, but also constitutional law, administrative law, surveillance, and a variety of other topics. And so I get to manage a wonderful team of people who are working across all of those areas to try to, again, shrink the footprint of government and more faithfully enforce and apply the Constitution's principles of limited government.
Well, and for those of who don't know, the Cato Institute would be called a nonprofit, so a business of sorts. So they survive through donors and people that believe that they are contributing to the world and to our government by sharing ideas and research that help make for better legislation, what I would say, better law, better rule. You might say that better. But I know one story where whether or not you think there was people doing things wrong or right, or Trump was wrong or right, or the Democrats were wrong or right, or Republicans, I know that Cato had something to do with trying to improve the clarity of the transition of power when a president is elected. And those are big things that Cato is involved with, and helping Congress be a resource to improve those laws for clarity. I just know that as one of many examples, and you were involved in that and so many other things.
Yeah, no, I appreciate that. Obviously, the 2020 election exposed a number of gaps and shortcomings in our electoral process, and my colleagues at Cato and I were played a role in helping Congress reform some of those laws to try to minimize the opportunities for mischief or bad faith complaints or challenges to elections. It's incredibly important that we ensure the smooth and peaceful transition of power in this country after there's been an election, unless there's a genuinely bona fide problem with the way the election was held, which generally there is not. I'm not saying that it could never happen. I'm not saying that it never has happened, but there's a difference between being able to identify, some issues in a number of jurisdictions. Country of over 300 million people, there will always be some issues in elections. So we're not looking for perfection. That's not reasonable. What we are looking for is to ensure that there are no systematic efforts to undermine the accurate counting and recording of votes. And so we were, able to contribute some important insights on how to reform federal election laws. And we had a smoother process this time. That's not necessarily entirely because of the reforms that were undertaken in 2020. It helped, I think, that we finally had a decisive victory by one of the candidates. Not everybody's choice, by the way, I know. But it was a decisive victory about which there was no real dispute. And so fortunately, we were able to avoid another episode like we had in 2020, which I think is all for the best, whether you're happy or disappointed with the outcome of the last presidential election. The fact that we're not going to endure weeks or months of challenges and dispute and contention about who won is, I think, on balance, a good thing for the country.
Oh, another of the many highlights of your career, you start out doing pretty well just in UT, where you were editor of Law Reese, you've always been an exceptionally bright person, but it's not very many lawyers that have something as consequential as the Heller case. If you want to give a quick summary of that, I think people might be interested. I know they would.
Yeah, you bet. I appreciate it. When I was in law school, I didn't go to law school with a clear idea of what I wanted to do. I knew that I loved constitutional law. I had been a philosophy major undergrad, but I didn't have sort of a burning desire to go out and be a lawyer. I didn't really know what different kinds of lawyers there were. But I did ultimately, after working for a few years in a big law firm and getting a taste of that. And I really had a great experience, worked with some great colleagues, but I also knew that it wasn't what I wanted to do for my career. I had made my way into public interest work, as we talked about before, at the Institute for Justice. And while I was working on constitutional cases there, one of my colleagues and I were sort of keeping an eye on cases involving the Second Amendment, which for most of our history was not a very interesting area of the law because the Supreme Court simply refused to give any definitive interpretation of the Second Amendment, which is to say, resolving the dispute between one group of people who think that the Second Amendment protects an individual right to own a gun and another group of people who believe that the Second Amendment, because of the so-called militia clause, the first part of the Second Amendment says a well-regulated militia being necessary to protect for the security of a free state. A lot of people put a lot of weight on that and say, well, whatever this is, it's not an individual right to keep and bear arms. It's a militia right or a government right or a state's right or something like that. And as of 2001, that is the way that all of the mid-level federal courts of appeals who had weighed in on the issue, that's the way they'd come down. They'd essentially said, well, it may not be entirely clear what the Second Amendment means. We're not entirely sure ourselves, but what we know that it doesn't mean is it does not protect an individual right to own a gun. But the depth of analysis was pathetic. There was no real engagement with the text or history of the Second Amendment. And it wasn't until 2001 when the Fifth Circuit Court of Appeals, which covers my home state of Texas along with Louisiana and Mississippi, became the first federal court of appeals to take a serious look at the meaning of the Second Amendment. They wrote like a 65-page opinion with a tremendous amount of historical and linguistic analysis, which was completely absent from all of the other cases that had come before. And the Fifth Circuit broke from the other courts and said, well, we think it actually does protect an individual right to own a gun. The Supreme Court still did not get involved at that point. But my colleague Steve Simpson and I looked at this and essentially concluded, as working public interest lawyers, that the question of the Second Amendment was likely to finally get to the Supreme Court, and that it was important that it go up in the guise of a sort of sympathetic, carefully designed public interest case of the kind that we worked on, as our day job, as opposed to going up, let's say, in the context of a criminal prosecution where somebody was prosecuted for sticking up a liquor store or dealing drugs or something like that, and they essentially said, well, I shouldn't have done that crime, but I had a constitutional right to the gun that I used as part of that. That would be obviously a bad setting for a case trying to vindicate the Second Amendment as protecting an individual right. So several of us got together and we recruited some wonderful plaintiffs. We had 6 different plaintiffs ultimately from all walks of life, all demographics, but all of whom had the common desire to own a gun for self-defense at home here in Washington, D.C., which was then the most restrictive jurisdiction in the country. Washington, D.C. had a complete ban on handgun ownership and permitted people to own shotguns and rifles, but the law actually prohibited ever putting a round in the chamber. So you basically had a right to own, or you had the lawful ability to own a club in the shape of a shotgun or a rifle, but you could never load it. So long story short, we challenged DC's ban on functional firearms in federal court in Washington, D.C. That case made its way up to the U.S. Supreme Court in what came to be known as the Heller case. And in 2008, the Supreme Court, for the first time in our country's history, delivered a definitive interpretation of the Second Amendment, in which the court concluded by a 5-4 vote that the Second Amendment does in fact protect an individual right to own a gun at home for self-defense. And in the years since then, there have been several more cases in which the court has begun to flesh out contours of that right, the same way that it does with any other right, free speech, free religion, et cetera, to say what is and isn't protected. And in some ways, it was a real highlight of my career as a constitutional lawyer. And somewhat ironically, that case was not a Cato case. It was not an Institute for Justice case. That was a case that just 3 of us worked on our off time. It was a case that we worked on nights and weekends. managed to get it up to the Supreme Court. And fortunately, because we were on the right side of the case, I mean, we worked very hard on it. I think we were very smart. We did some good lawyering, but what helped the most is that we were on the right side of that case. The individual rights interpretation of the Second Amendment is far and away the most plausible one. People who take the other interpretation have a very difficult time saying what that amendment is doing in the Constitution, what actual function it serves. And so it was good to be on the right side of the case. And, and I'll always be proud of the fact that I was part of a team of people who helped to, revive 1/10 of the Bill of Rights. And that was really the reason that we got into the case. It wasn't so much about guns. It was mostly about ensuring that no one provision of the Bill of Rights be functionally read out of the Constitution by giving it no substance. That's what concerned us the most as libertarian constitutional litigators. And really the fact that the case was about guns was secondary for us. What it was first and foremost was about not permitting a world in which 1/10 of the Bill of Rights could be given, effectively no meaning by people who just, for whatever reason, didn't feel that enforcing the Second Amendment was an appropriate thing to do.
Inspiring story. And because I've gotten to know you, I think fairly well, I know that you wake up every morning and you want to make a difference in the country, and big things, big things you're always thinking about. Cato's thinking about, IJ was working on, you did before. And I know I met you and Nikki and the kids got to meet my mom. And I think a lot of people in that generation used to think about that. She worked for the government, and I hope we can instill that as much as our fathers. I know you have an interesting story about your father, who I expect helped instill some of that because he was a remarkable man. Um, would you like to share a little bit about that? I know it's a great story.
Yeah, I appreciate it. And I hope you'll prompt me if I don't tell the story that you were looking for. But my father, we share the same name. I'm actually Clark Neily III. He's Clark Neily Jr. He grew up in Maine. He went to the University of Maine where he studied physics. And his first job out of school was he went to work for NASA when they were working on the Gemini space program, and quickly transitioned from there to the Apollo program. And so was intimately involved in helping put a man on the moon when he was in his mid 20s, which I think is pretty spectacular. He actually knew the astronauts who flew those missions, was on a first name basis with the crews. He actually helped write the procedure. For those who remember how it worked, when we finally did put a man on the moon, the spacecraft actually divided in two, and the command module continued to orbit the moon while the lunar lander went down and took Buzz Aldrin and Neil Armstrong to the surface of the moon. And then when they were done down there, they had to fly back up and rendezvous with the command module while it was orbiting the moon. That's an incredibly difficult and important procedure, because if you miss, the two people in the command module, I'm sorry, the two people in the lunar lander are not coming home. And so my dad and another person actually wrote that procedure, and I have a copy of it that's signed by all three astronauts on that mission. And so, I was never very proficient in math. My dad helped tutor me through calculus when I took that in high school, and just never really stuck. But I think it's pretty amazing that he was helping put a man on the moon as his first job out of college when he was in his 20s, and it's very inspiring to me. I think I've looked up to my father and tried to live up as best I could to that legacy, even though I don't have the same aptitude that he did. But I've tried to make up for my lack of facility in math with doing better in constitutional law. So, but he's been very supportive, and we used to have sort of good-natured arguments about who had the most impressive career. And I told him not even getting to the Supreme Court in a Second Amendment case, as far as I'm concerned, can compare to helping put a man on the moon. So, but as I said, very inspiring figure in my life, and someone I love tremendously.
The son of a rocket scientist who's
Yeah.
a constitutional genius, I'll call you. How about that?
Well, I don't know if that, but certainly the son of a rocket scientist who, by the way, jokes around about how he said, when people say it's not rocket science, he said that's actually what I do, and he said I don't think it's that big a deal, but it is. It is a big deal. But he's self-effacing.
I just really even know where to start, because there's so many issues that you're involved in. When you chose to teach at law school as an adjunct professor, and I know you've done that at least twice, but what's kind of your focus with the students for some people that would like to make a contribution like you one day, and what
Yeah.
class do you teach? Yeah.
So what I taught was, the class was called public interest litigation, and essentially what I tried to teach were the skills that I had acquired over the years as somebody who challenges the government in court and specifically in the context of strategic public interest litigation, which is to say, you pick an issue like trying to reform or eliminate civil forfeiture, or try to eliminate qualified immunity, which is a defense that the Supreme Court invented out of whole cloth for police and other government officials who've been plausibly alleged to have committed civil rights violations. But essentially to try to share with the students those strategies about how to successfully litigate public interest cases against the government, challenging the unconstitutional exercise of government power. And what I had concluded after, almost 20 years as a public interest litigator is that when you square off against the government in court, you will almost always find an extremely unlevel playing field, in the sense that the government has all kinds of special defenses that other people and organizations don't get. They have all kinds of procedural protections that other people and organizations don't get. The case will go to court in front of a judge who, we actually did a study on this. There's a pretty good chance that judge will have worked for the government as a lawyer at some point in their career. And so a lot of what I tried to teach the students was how to try to neutralize some of these illegitimate advantages that the government possesses when you square off against the government in court, and to sort of, kind of try to see what's likely to be coming and the different ways in which they will try to play the special cards that the Supreme Court and Congress and others have given them. And, in effect, it's sort of like trying to say, if you were going to have to play in a poker tournament where the other players are allowed to cheat, how would you play that game in such a way as to neutralize the advantage they get? And I'm not saying, by the way, the government lawyers always cheat. I've seen it happen, but I'm not saying that's the main problem. The main problem is they've been given so many special advantages, so many ways in which the rules that apply to everybody else do not apply against them, that it feels like you're playing in a poker game where the other players are cheating because they are not playing by the same rules that you are. And so that's really what I tried to teach the students, was how do you manage to win cases in an environment and against an opponent where the playing field is highly unlevel, and you can't always count on the referees to be perfectly neutral. And I'm not saying, by the way, that just because the judge represented the government in court before they became a judge, that means they can't be neutral. I clerked for a judge who did that, and he was an absolutely stellar judge, and actually had a reputation among government attorneys as not being fair to them, which I dispute, by the way. From my perception, what he did was hold them to the same standard as everybody else, which they perceived to be very onerous. But the point is that if you're going to be effective in public interest litigation, you have to have a very clear understanding of all the special advantages that the government has and how it tries to benefit from those and improve its chances in court. And it's not possible to really neutralize all of them, but there are definitely better and worse ways to square off against the government, and things that you can do to try to minimize the illegitimate advantage that they possess on the unlevel playing field of constitutional litigation.
What a great wrap up, teaching students how to make change with the government, and I guess actually implementing some of Cato's views. And my views too, by the way, just to weigh in on one side, that I think the government gets too big and too much power too often. And I love America, and I find that sad and disappointing when I hear the stories. And Cato has a lot of those stories, and so does Institute for Justice. I don't know if there's anything else you'd like to say, but to me, that's a great place to wrap up. I know that I always learn something when I talk to you, Clark, whether it's on a podcast or we're sharing a glass of wine. So thank you for all you do and for coming on today.
Well, thank you, Henry. It's been my pleasure. And I guess I would just leave your audience with this. We are facing obviously a lot of challenges these days. We're quite polarized, and many people are feeling discouraged. But I'd like to leave people with one thought, which is that we do have the benefit of having the greatest constitution of any country in the world. We have, more than 100 years of constitutionally limited government in this country. Unfortunately, the government doesn't always respect and obey the provisions of the Constitution, but we have a system for pushing back and for improving that. And so that's sort of my biggest ray of hope for me and for my kids, and hopefully for their kids, is that we live in a country that has more than 2 centuries of dedication to limited government and the rule of law. And to the extent we stray from that, we can find our way back. And we'll always have as a beacon the United States Constitution, which is a tremendous liberty document. That's what Dred Scott said, by the way, the former slave, is a glorious liberty document. We should never forget that.
Terrific. Thank you very much. Talk to you soon, Clark.
Sounds great.